not. This is a very relevant issue, and when anyone can go to Google and try to check, negatives are more than the positives. And what is the reality? I have seen, and generally people around us talking about, in every family, at least one or two members are having Apple cell phone or MacBook, and that's why they are explaining that what's happening and how they are feeling helpless. Reality is Apple is facing many allegations, and consumers as well as app developers from those allegations. And later year in last year in EU, and in last month in UK, antitrust authorities opened a probe into Apple Incorporation and its Apple Store. And the issue later on, I'll come up what was the issue. Specific issues are there, and those majorly most are those consumers and app developers. They are blaming Apple for monopolistic behavior, distorting competition, charging very high prices as compared to competitive prices available in the market. Apple locks its consumers. Apple tax, as has been mentioned, that I'll briefly discuss what is Apple tax and how Apple is rotten. Then discriminatory behavior against few app developers. These are major issues, and that's why this is the introductory part. Now, why I have chosen this topic, someone may ask, why not you have taken the Google Play Store, Google Play, because more apps are available as compared to Apple. So see, first thing that I want to show you that Apple's net income worldwide from the first quarter of 2005 to first quarter 2021, you can see the increasing numbers, and huge, massive amount of money is involved. As in caption, I have mentioned that Apple worldwide annual revenue that was total 274 billion US dollars in 2020 fiscal year, and Apple is the world's largest technology company by revenue, and since 2021, the world's most valuable company also. And in August, publicly traded US company to be valued over 1 trillion. And in August 2020, became the first company having the 2 trillion US dollars. So this is a massive amount of dollars are involved, money is involved, and that's why if there is a slight impact or slight anti-competitive behavior, the resultant impact over the consumer and the market would be very huge. The numbers of available apps on the App Store from 2008 to 2020. This is the graph what I have shown. Then Apple's net worldwide gross app revenue, specifically app, if we'll concentrate in 2020, it is 72 billion US dollars. And in total, the app revenue, including Android and iOS, it was 111 billion US dollars, where it is increasing 24% increase year on year. And if we compare 111 billion, 65% revenue goes to Apple. That's why I have taken this topic. And first I thought, okay, to deal with the App Store, and probably next time I will also see what's happening in Google Play Store. The problem, coming to the problem, exactly as I told you, problem is three-dimensional basically. One problem is from the consumer's perspective, Apple. Another one, the app stores, app developers perspective, and the third one, competition agency perspective. So from consumer perspective, Apple locks Apple devices owners by the app store. This is one allegation. Consumers, they said, they are forced to purchase apps at a very high and non-competitive rate. And the third one, that due to this lock-in, consumers are not having any other option available. It's a kind of a closed other options for them. From app developers, which is very famous, that 30% cut by the Apple, and that's why Apple keeps 30% of the sales price of apps, and without any contribution to app developers. And the app developers must pay the 99 annual membership fee also, and that's why these are major concern by the app developers. From competition agency, and for scholars like us, students like us, they are studying competition law, trying to get equipped with the latest tools and techniques of competition agencies, to how to understand the anti-competitive behavior and how to curtail it. This perspective is regarding if there is no justification for such an agency model of 70-30 model of apps store, then it may be monopolistic behavior what competition agencies are, they are presuming as of now. And possibility, they are also presuming like there is a possibility of distortion of competition and lesser choices to consumers, and huge amount of money involved. and Apple easily evading competition agencies, claiming that they do not set the prices of apps, they are not owning the apps, and that's why they are not doing anything which can be claimed as the monopolistic behavior. Now we have to study the App Store model 70/30. What exactly is this? So I have taken one example from the publisher's perspective, one product that is the ebook. So what exactly happens, like the publisher sets the retail price of a particular ebook and it launches on App Store. And through App Store, consumer can access that ebook and Apple must sell it at the retail price what is set by publisher. Apple doesn't set, and Apple only provides the platform. Consumer pays the retail price that the publisher not that to the publisher not, and the price is set by the publisher, not by the Apple. It means Apple is only providing platform. What Steve Jobs mentioned, that I'm just going to, and we are just going to provide a platform where the app developers, they will develop, Apple will not develop, and Apple will or only collect 30% of the prices here, just because of this platform. Then claims of consumers in an elaborative manner. When I've gone through with all those issues and the few Supreme Court cases of United States. So major what crux they have what exactly is the crux of claims of consumers, like Apple exercises monopoly power in retail market for the sale of apps and have unlawfully used its monopoly power to force iPhone owners to pay Apple higher than competitive price for apps. This phrase is very much important, because if they are locked in and it is not higher than competitive price, then there is no problem at all. As such, there is no problem. But they are claiming that due to this lock-in and due to the excessive monopoly power of Apple, the consumers are forced to pay higher than competitive prices for apps, and this is a major issue. Consumers, they are claiming, like, we have only two options. One option is buy the app from Apple's App Store at a higher than competitive price, or do not buy at all. You can sacrifice if you want to purchase to beautify your uh, um, uh, your photos, and is there any price set by the app developer which is available on the App Store? Either you can buy it over there and you pay through the Apple Pay, or you don't buy it. This is the two options available. In this background, in 2011, what happened? Four iPhone users, they sued Apple in United States, and case initially was went into the favor of Apple. Then it went into to the circuit court, where in the appeal it was the decision was reversed, and finally when it came to the US Supreme Court, where the entire matter was analyzed, what consumers, they said, they alleged that Apple has unlawfully monopolized iPhone app markets, and they also claim that via App Store, Apple locks iPhone owners into buying apps only for Apple, paying 30% extra or Apple fee, which is included in the app. And if iPhone owners wish to buy apps elsewhere or pay less, they do not have any other option. If similar apps are available outside the App Store, they cannot buy, because of this lock-in issue, and they are totally forced to purchase from the App Store. In 2011 case, it has been properly quoted and it has been reported in US Supreme Court. Now, coming to the claims from the app developers, there may be many claims. Only few I have taken up here. Like, does Apple create? First of all, we have to see, does Apple create apps for itself? Answer is no. Then who creates? Rather, independent app developers create apps for Apple, and then how it interacts? Those app developers, they develop the app, but they need a platform, and Apple has a huge number of consumers and users of iPhone, iPad, MacBooks. So in that case, those developers, they want a window where they can sell. So that's why a contract is very much required between app developers and Apple. And this is the reason of distress of app developers. What is happening here? Those independent app developers then contract with Apple to make the apps available to iPhone owners in App Store. One contract is there. In that contract, two major things what I have seen, that is to sell an app in App Store, annual fee that is $99. In that contract, it is written over there. annual membership fee, and 30% of sale price. 30% of the sale price, no matter what the sale price might be, it may low, it may up, but Apple needs 30% what exactly is the sale price. And that's why many discriminatory behaviors are also there, what app developers they are claiming nowadays, Spotify, one dating app that is I just forget the name. In my slides at the end, I have discussed that few apps, Apple, for few apps they are cutting for 30%, for few apps they are not cutting. So what exactly is the justification of Apple, whether it is justifiable or not? And what this 30% cut is, when we analyze this 30% commission model, which provides a pure profit for Apple without any justification. Without any justification. Although Apple has given the justification, later on I'll put forward what exactly is the justification of Apple. But in my opinion, and a few other scholars, they also mentioned that it is not justifiable what you're talking about. Defense of Apple or arguments of Apple. Apple argues, against all these allegations, and Apple has taken defense based on Illinois brick rule. That consumer is, in this case, when consumer they are claiming that Apple is charging very high, and they are claiming from Apple that you are doing your anti-competitive behavior and monopolistically you are, charging very high. So in that case, Apple argued, and Apple based its defense on one Supreme Court case of United States, Illinois Brick Company versus Illinois in 1977. And this Illinois brick rule is very much important to understand how Apple is saying those consumers is not a direct purchaser from Apple, and that's why Apple is not liable. Apple said that we are only service providers, we are platform providers, and we are not setting the prices, we are not developing we the apps, and that's why we are not responsible for any sort of monopolistic behavior, because we don't set the price. Prices may be very low, prices may high, but we don't set. And that's why the question arises, then who set the prices? This is very important question. Prices are set by the app developers. Why they are setting? Because Apple has come up in 2008. Apple has come up in 2008 this agency model, and Apple says we are in the form of intermediary, and we don't own those apps. On this, what is Apple theory? Apple theory is code should transform direct purchaser rule into the who set the price rule. Like if they are talking about direct purchaser rule, which has been identified in Illinois brick company case, if directly we will apply what Apple wants from the court, that you just interpret it like who sets the price, and then only that person is only responsible. Apple insists that the three reasons that court identified in Illinois brick for adopting the direct purchaser rule apply to this case. And those three rules, like it is in the form of the economic transaction, who sets the price, who controls the prices, then and who owns the app. We don't own the app. All these justifications have been given by the Apple, and later on we will see what is exactly is the conclusion of court and what is our opinion. Then it is very much important to understand what Apple is talking about, that consumers are not proper plaintiff, because they are not direct purchaser from Apple. They are purchaser from the app developers. This question is before the Supreme Court in Apple Incorporation versus Pepper et al., which has been in 2019. This is very important case where Supreme Court held that in Illinois brick company that direct purchaser may sue antitrust violators, but also rule that indirect purchasers may not sue. This is for which Apple is to just manipulate uh, uh, Supreme Court of United States said that purchaser may sue the antitrust violator. And what Apple says, we are not so consumers are not direct purchaser from Apple. What Apple is taking the defense. What Apple theory of direct purchaser is, like Illinois brick allows consumers to see only the party who sets the retail price. Although it is not mentioned in Illinois brick company, this is Apple's understanding that court should interpret in this manner, and whether or not the party sells the good or services directly to the complaining party or not. Apple doesn't sell the Apple doesn't set the prices. Who set the retail prices? That person is responsible. That company is responsible. This is Apple's theory. This is Apple's theory. So before going further, whether this theory is correct or not, we have to understand what exactly happened in Illinois brick rule and what exactly is the case. So this is a brief understanding what I have taken the crux and represented here. Like Illinois brick company manufactured and distributed concrete blocks. Later on, in the supply chain, this Illinois brick company supplies a masonry contract, all those bricks to concrete blocks to the masonry contracts. Those masonry contracts contractors further send it to or supply it to general contractors, and those general contractors provide the larger construction project to the state of Illinois. So in this case, it has been identified who is the ultimate consumer. Ultimate consumer is the state of Illinois. And when this rule says, what Illinois rule says that this representation what I have made, like if A is the retailer and C is consumer. So according to Illinois brick rule, C may not sue A because in between A and C there is B. B is intermediary. And B may sue A if A is the alleged antitrust violator. C may sue B if B is an antitrust violator. But directly C cannot sue A because in between there is a line of B and the intermediary. This line has been identified in Illinois rule as a bright line principle or bright line rule, like on roads, there are stop line. So this line, what Supreme Court said, this is a bright line. If this bright line demarcates A and C, C directly cannot sue A, but B may sue A if A is the alleged antitrust violator, and C may sue B if B is the alleged antitrust violator. This is the principle what Supreme Court said. What Apple is saying, that is something different. Now we have to analyze what Apple is saying. Apple consumers are proper plaintiff or not? According to Apple, no. Apple doesn't consider that they are proper plaintiff because they are not direct purchaser. Reason, they are not the direct purchaser. So how to understand it? It can be analyzed from two perspectives, and Supreme Court also has taken these views. What are those two perspectives? We have to see the what antitrust law says on that point and what precedent, if any, because these cases are very having the new dimension. This is not the old monopoly. This is a new monopoly, or you can say the virtual monopoly many times. So we have to maybe we have to draft a new law, and we have to think about new interpretations from the court, so that very new jurisprudence would be developed in the name of precedent. If we see antitrust law, specifically I've quoted here only the United States, similar provisions are available in EU as well as in India also, although in India, similar type of cases, at least I have not seen as of now. So I have taken the reference from United States. What US law says, Section 2 Sherman Act. Sherman Act makes it unlawful for any person to monopolize or attempt to monopolize or combine or conspire with any other person or to monopolize any part of trade or commerce among the several states or with foreign nations. This is Section 2. If this Section 2 is read with Section 4 of the Clayton Act, it is very clear, like Section 4 of Clayton Act, what it says, any person who shall be injured in his business or property. So please underline this, shall be injured or in his business or property by reason of any forbidden thing in the antitrust law may sue the defendant and shall recover threefold the damages by him sustained and the cost of suit, including a reasonable attorney's fees. If we read both the sections, Section 4 Sherman Act, Section 2 Sherman Act, and Section 4 Clayton Act, both covers consumers who purchases goods or services at higher than competitive price from an allegedly monopolistic retailer. And that's why precedent in Illinois case, as I have told you, that bright line rule, who are two or more steps removed from the antitrust violator in the distribution chain may not sue. And the state in Illinois brick case, There's a message from discussant. Could you please explain, because I cannot see my chat box?
You continue, sir. You
No,
continue.
that is not. You continue. You continue. Last
Okay, okay,
10 to
okay,
12
okay,
minutes.
okay, okay.
Please continue.
Yeah. I'm just concluding. So, according to principle, this bright line principle, if the claimants, they are far from one or two steps from the alleged antitrust violator, which I have explained here in this slide. In this slide, I have explained that this is the bright line B. There is a bright line, so they cannot just they cannot claim for any sort of antitrust violation. And the Illinois case, the state alleged that Illinois Brick had engaged in conspiracy to fix the price of concrete blocks. It may happen, but the state of Illinois did not purchase directly from the Illinois Brick. There are two intermediaries involved, and Supreme Court said that the state could not bring an antitrust action against Illinois Brick on the basis of bright line rule. Another case in 1990, that is Utilicorp United Incorporation, while applying Section 4 of Clayton Act, court categorically mentioned that we have consistently stated that immediate buyers from the alleged antitrust violators may maintain a suit against the antitrust violators. If in between intermediaries are there, they cannot. And that's why principle of proximate cause has been identified here, like indirect purchasers who are two or more steps removed from the violator in the distribution chain may not sue. What Apple is trying to misinterpret these principles and try to take the benefit from the misinterpretation of the principles stated by US Supreme Court. Now, if we compare this rule with the App Store model, app developer one side, App Store platform in between, and Apple user and consumers. So what prices are set by app developer? It goes through the App Store distribution, and Apple consumer pays through Apple Pay, and it goes 70% goes to app developer and 30% after the 30% cut. What exactly is the outcome? Outcome is the iPhone owners are not consumers at the bottom of a vertical distribution chain at all, who are attempting to sue manufacturers at the top of the chain. And there is no intermediary in the distribution chain, because Apple is directly connected with the consumer. In between Apple and consumer, there is no intermediary available. And the iPhone owners purchase apps directly from the retail Apple. Who is the alleged antitrust violator? iPhone owners pay the alleged overcharge directly to Apple, not to any third party, and that's why the absence of intermediary is a dispositive in this case, and this case has to be decided on those matters. And that's why, therefore, according to me, Apple argument is wrong, and consumers are directly a direct purchaser and proper plaintiff in these cases. Now, another issue, when Apple is saying that we are not setting the prices, a very interesting thing, only 2 minutes I'll take to explain this, because this is very important. Apple is trying to, just trying to manipulate the entire scenario in a manner that Apple efforts to transform Illinois Brick from a direct purchaser rule to who sets the price rule. And in doing so, what Apple is doing, an arbitrary and unprincipled line among the retailers have been drawn by the Apple. How? For this example, it is very easy. For example, in a traditional markup pricing model where a hypothetical monopolist retailer might pay 7 rupees to manufacturer, takes the good and sell it to the 10 rupees to the consumer, and keep $3 to itself. This is named as the markup pricing model, that you are purchasing from the manufacturer at rupees or at $7 and selling it to at $10 and keeping $3 for yourself. In a commission model, what happens, that retailer might pay nothing to the manufacturer and agree with the manufacturer that the retailer will sell the product for $10 and keep 30% of its sales price, and then sell the product $10 and send back $7 to the manufacturer and keep the $3. If we apply the Apple principle in those two different pricing scenario, what I have explained, the result would remain same, because everything turns out to be economically the same for the manufacturer, retailer, and consumer in both the cases. And Apple proposed rule, in if will apply the Apple, that who sets the price, that person is responsible. So Apple proposed rule would allow a consumer to sue monopolistic retailer in former situation in the markup pricing model, but there is no obligation in the commission model, what Apple is trying to avoid through these type of interpretations. Now coming to when Apple is trying to justify 30% cut, that is justified. Right hand side, I have given one information that protecting App Store users for prevention in 2020. These many apps rejected for being spam, copycats, then for hidden and undocumented features. And Apple is trying to portray that we are very much careful about our consumers and we are taking very much for their care. And Apple justifies for all these things 30% take by examining that it uses that money. What Apple says that we are taking 30%, but we are providing you a platform, very secure platform, and see, this is the data how we are securing you. But in US in-house antitrust committee report, what it says that Apple Apple spends around or more than $100 million per year. This is a very huge amount. But in the same report, it has been mentioned that how much Apple earns. Apple earns around 15 billion, which is 15,000 million, and 18 billion in between a year from the App Store. 15 billion to 18 billions Apple is earning, and what Apple is portraying that 100 million per year we are spending, and that is a very huge margin business, and Apple's investors love it, and this may have forced Apple to continue press developers apps developers for revenue shares. By mistake, I have written to press, rather it is apps. Now coming to the specific violations, this is the last part of my presentation. A specific violation, many violations are there, like prolonged Apple tax since 2007-8. Apple is saying like 30% is nothing, and in last slide I have just argued that what 30% they are taking and what they are spending, there is a huge difference. There is what they are saying, like we are taking for the protection of consumers, but for how many years? For introducing, nobody can deny that you are a very revolutionist and your invention was very good, and it was really innovative in year 2007-8 when you launched the iPhone. In one device, many things you have included. At that very moment, you are saying 30% we are charging just because of our innovation. But in 2021, after 14 years, still 30% is there. And someone may say, counter me on this point that no, last year they have reduced it up to 15%. So I would like to quote one statement of Judge Roger. What Judge Rogers said, that you have just reduced it from 30% to 15% for not all the app developers, rather few app developers. And this is not just because of the competition, rather there's a pressure from the judiciary, and rather there is a pressure like you would be charged with the anti-competitive prices and you would be charged with the anti-competitive behavior, not for the competition you are doing this, rather to avoid these proceedings you are doing this, reducing the 30% cut to reduce to 15%. Another violation, that is no alternative payment method is available. Like Judge Roger in Oakland, California, asked to CEO Mr. Cook that why you don't allow people to choice in how they pay for digital goods. Why other options are not available? What Mr. Cook has replied, I'm surprised to see. Mr. Cook said that if what judge said, that if Apple cares so deeply about users agency, why not allow people to have a choice in how they pay for digital goods? You just open it, they can choose it. But what Mr. Cook has replied here, Mr. Cook said that if we would in just provide the alternative method, in we would in essence give up our total return on our intellectual property. In the name of intellectual property, you can charge 30% throughout for 500 years, you can charge. So this is not a justification. And another issue, like right inside one picture, I have mentioned, probably few of my colleagues, they are very much aware what I'm talking about, the AirTag. And the leading company was Tile, and Tile was also available through the App Store. But when Apple announced its version of personal thing tracking device called AirTag, this is a bad news for Tile. So there's nothing bad, because anybody can develop a new device. There is no problem. Problem starts when the Tile says there is a assumption like AirTags will be integrated into iOS. Definitely, it would be done. So the iPhone will pair with AirTags with a greater ease and more, more precision, and while Tile is objecting because Tile is not allowed to access the unlimited. Just a minute. Yeah. Tile is not allowed to use ultra wideband connection, which is available in iPhone, and Tile is denied by this access of the ultra wide band radio in the iPhone, and that's why Tile is having this apprehension that this is a very big problem, and people definitely would shift from Tile to this air tag. Then this is also very interesting picture right hand side, Fortnite. This is a game which has been developed by Epic Games. This issue is also going on in European Union, because what happened that Epic Games in last summer, Epic Games, which makes the blockbuster video game Fortnite, sued Apple over the strict control the company maintains over the
Atipji,
software on
please
iPhone.
conclude. Please conclude.
Okay, time exceed.
2 minutes more,
I'm
please.
okay. Within 2 minutes, I'm concluding. So in Epic Games, suppose you are playing the Epic Games this Fortnite, and if you want to take this avatar, Fortnite digital hamburger avatar, you have to pay, and 30% directly go to Apple without any effort. Then Spotify issue. That is Spotify issue is the same thing. What is happening, and this issue is also pending before the European Union, that Apple is not giving the proper preference, and level playing field is not available, and Apple is abusing its power. Then finally, this Uber and Tinder. Tinder, it's a dating app. While for rides, for Uber, you are not charging 30%, but for Tinder, you are charging 30%. This is not a proper justification. What Mr. Cook said, that for digital for product we are charging 30%, but Uber is not purchasing any in-app sales, so we are not charging 30%. So all these justifications are mere justification by Mr. Cook, but courts are not satisfied, and even US in-house committee is also not satisfied. In conclusion, what I would say, that nobody can deny that Apple is most creative company in the world, and in general it watches out for its user privacy, etc. But continuous complaint says there's not something, but many things are not in accordance with the competition rules. That's why many claims and complaints are there, and Apple is using its position to set the terms and unfair or restrict competition and choice, which potentially causing customers to lose out when buying and using apps, which is anti-competitive up to a certain extent. And it is really very difficult. If someone would suggest, why can't we enact a law? Enacting an entire law on this issue, this may have unintended outcomes as a bigger concern. That's why we have to be very careful about all these issues, and some slight changes definitely would work and better arm the competition agencies. That's why we have to think about certain changes. And since Apple has a clear market power in app business, and that's why, because its software tend to lock users into its ecosystem, that power must be policed. That power must not be unpoliced and unrestricted, and that's why competition agencies should be very careful about that. Thank you so much. Over to you, Suryaji. Thank you so much.
Yeah. Thank you, Dr. Atipji, for his wonderful presentation. So we have certain questions. We have a question from Dr. Y. Paparao, sir. So as per his understanding of this present Apple case is concerned, that Apple tax is justified, that the revenue contributes towards the cost of maintaining the App Store and enforcing its various content, privacy, and security policies. Hence, it does not amount to unfair price, according to him. Is there any nexus between Tulip Pneumatic Tire Company Limited versus Selfridge Company 1915 case as per the UK competition law is concerned? Can you throw some light?
Sir, your question might be very relevant here, but I'm really sorry, because in my paper, as of now, I have not just included this case, a specific case, Tulip Pneumatic Tire Company versus Selfridge. The entire idea when we are talking about the taxes, from two perspective we have to see. I'm not talking about this specific case. I'm talking about the general idea of taxing or taking some cut. Two things we have to see. Suppose you are providing a platform. Many of the two-sided platform markets are there nowadays, and they are charging also. But the thing is, what is your contribution? Your report, your executive only says that we are spending 100 rupees, and you are charging 1 lakh rupees. So this is not justified. So when you are talking about the taxes, there is no problem at all. You can charge, and even courts are very much concerned. Like you may charge some sort of cuts, 15%, 10%, 5%, whatsoever is reasonable in the name of intellectual property. Because even in competition law, whether it is UK, EU, US, or India, there is an exemption for intellectual property, but it also says that your exercise of intellectual property should not be abusive. You have to take care of it.
Okay, sir, I have two questions
Yeah, please.
relating to this topic.
Yeah, please.
So, the Apple, the present case which is pending before United States, UK, and European market authorities, the competition, the watchdogs, so the
Hmm,
antitrust watchdogs. So, in order to decide the dominant position and which is leading to abuse of dominant position, so
hmm,
they have to go with certain factors in order to decide the apple which is the enterprise which is leading to abuse of dominant position is concerned. What are all the factors which need to be considered by these authorities, market watchdog authorities, in order to
hmm,
decide whether it led to the abuse of dominant position or not? One. The
hmm,
second one, what exactly here the relevant market in the present
hmm.
case? Can you give some light?
Okay. Okay. The thing is, the first question when we are talking about that, what are those factors to identify the dominant position? Like in India also, Section 19 Clause 4, which talks about certain factors, approximately 12 or 13 factors are there. In US and EU also, those factors are available. Usually this was our approach, like anybody is dominant if that person is having 70% of market share, 60% of market, even more than 50%. This is not in the case of competition law, because in antitrust, even you may have a lower degree of market share, like in Apple, somewhere it is 25% in some jurisdiction, but still Apple is locked its consumers even in that 25% in revenue. It would cost a lot, because Apple is not only a device. Apple is also providing 5 services, like content, like iCloud, like Apple Pay, and other services are also there. I reminded of one statement between Walmart and Apple, that Walmart was talking about some prices of and the quality of iPhone that is very high. And what Apple replied, no, that when we would earn the consumers, all these things would come written to us. And what is happening today? Even when Google Play, more than 4 lakhs apps are available. More than 40 lakhs apps are available. But in revenue, even Apple is only having 25% of market share, but still Apple is more revenue than 65% out of 111 billion what I have quoted. Reason problem is because in Google Play, if we use Android phone, probably you have might have experience in Android platform, even you can download an APK file, and you can download and run on your phone over Android. But this is not happening in Apple. Someone may counter me at this very much. How you can say that on Apple we cannot download? Definitely you can download outside. It is something like one person is going with his or her Range Rover at a speed of 130, and if you'll or anybody will ask me, Atif sir, can you overtake this person with your Santro? I would say definitely I can overtake. Yeah, definitely I can, but at my own risk. You can download your software over Apple phone also, but at your own risk, because you have to jailbreak. The first very common thing, that is the jailbreak. Jailbreak is a kind of a software that you have to download, and through that jailbreak, those softwares would be uploaded over your Apple. But it might be possible that you are thinking that your Apple camera is off, but someone is watching you. It might be possible that you are not talking to over any call, but someone is listening you. And to avoid all these things, these security purposes, this type of lock-in, that is also very much required. The only problem is market share is not important. Other factors is also very important. How your competitors, whether they are having those technology, they are technologically rich or not, they are strong enough to compete with you or not. If I'm just going to fight, against a person in heavyweight like 80 kg or 90 kg, result is very obvious. Result is very obvious. No need to tell what exactly is the result. So the thing is, when we are talking about dominance, when that person entered into the market, what are those technological edges available? How it's all about the sometimes it is I usually mention that the concept of relativity of Albert Einstein is we can apply in many areas. So whether I'm right or wrong, I don't know, but many things are relative. It is not only that I have 30%. How other the entire market is segmentized? Might be possible that a market is segmentized like 5%, 10%, etc. And like many other factors are there. 13, 14 factors. That's why in EU, European Commission said, I do not remember the case. European Commission said that market share is mere a factor. It is not a sole factor. So on market share, all these things cannot be decided. Rather, we have to see the competence of the alleged company and how the competitors are competent enough or not to compete. So this is another issue, that is what exactly is the relevant market. So when we are talking about the relevant market, so in this question is very important and really very interesting and tricky as well. This question was raised in the United States also, whether this app store is a relevant market or not. Supreme Court said that this is very equivalent as a physical market, and where the two players are. What is a market? Market is nothing but a place where seller and purchase they interact. And what Supreme Court said, that this is app store is also a physical kind of a physical market, where app developers come and consumers come, and Apple is only taking and playing with the Apple Pay. That's why this is a proper market, what they have explained. I hope I have answered.
Yeah, thank you very much for your clarifications.
Thank you
And
for interesting questions.
I don't think see any further questions in the chat box. So, okay, with this discussion, now I would like to call our special guest of the day, Dr. Anidya Sarkar sir, to give his concluding remarks. Over to you, Dr. Anidya Sarkar.
Thank you very much, Professor Surya. Don't call me a special guest because I by now I feel I'm a part of HNLU. Okay. Uh, now, being there, I just wanted to, when in the morning I was speaking to your VC for a certain different aspect, he mentioned about this, and I said, oh, it's an interesting topic. I would like to attend, and that's how I landed up here. And now you put me in a fix. Mm. Now, to start with, I would just say, uh, Professor Khan, you did a wonderful job. Okay,
Thank you so much,
you
sir.
did a
Thank you so much. Thank you so much.
you did a wonderful job, not only putting all the facts together, but your lucid way of explanation is something which I have not heard for a long time. Okay, I,
Thank you
I
so
am
much,
very
sir.
much in the circuit, and that's something, and I strongly feel that you should go for a publication on this.
Thank you
Okay,
so much, sir. It
and
means a lot, sir.
I would love to go, let's say, cooperate with you if there is any need. Now, till
Sir,
the time I heard today, I used to feel helpless. I used to feel helpless because I'm still an addict to Apple. I use a MacBook, I use an iPhone, I use an iPad, and not only me, many of my family members, my wife uses an iPhone, my kids uses an iPad, and putting all that together, I used to feel a little bit of helpless uh, at times. Uh, Today, I feel I'm not only helpless, I'm imprisoned. And I'm imprisoned, just to add to that, it's not only because of App Store, it's also because of iTunes.
sir,
That's another,
exactly.
that's another pain for Apple users, and that's a real pain. And you know where? Uh, And having said that, it's just a coincidence that today morning I was in a meeting with some of the agencies in Delhi, where a few of your national or vice chancellors were also there, and we were talking about a digital tax, and the tax was for digital, which included Apple, Google, and few others. and we're talking about just 2% as a tax. That may be coming out very slowly, but you know, I'm very, very tempted to quote or to remember one of the interviews which happened with Mr. Tim Cook just after the litigation, where one of the journalists asked that why iPhones are so expensive. Okay,
Sure.
why iPhones are, I really love the sense of humor the Apple and the Apple employees have. And Mr. Cook was said, this is because the iPhone replaces a whole bunch of devices, like the camera, the watch, the music player, the video player, the PDA, the video recorder, the GPS navigator, the flashlight, the calculator, so on and so forth. Surely, when a device replaces all that, you should be paying a much higher price. See, the journalist was also not, was a smart guy, and he asked, the Android also does the same thing at a much cheaper rate. And what's hilarious is that Mr. Cook replied, well, the Android device just replaces one device, that is iPhone. So, having
Yeah.
said that, I'm not against, 15 billion earning of iPhone through apps. But what's the real pain is that you are locked, you're kind of imprisoned, you don't have a choice, and there is no, I can't recommend people to jailbreak. I mean,
So
that's I mean, being a student and a teacher in this field, you cannot do that, and nor should I be doing it. But
so
in having taken all that in account, um, this is really a difficult position. This is really a difficult situation, and we really have a lot of people who will be who are affected. And as things are going, I don't see us, a light at the end of the tunnel. At the most,
yeah.
we can impose digital taxes. And see, this digital tax is not for the one which you pointed out. This digital tax is mainly because they are collecting and using data of a specific jurisdiction.
So
So overall, it was a wonderful experience.
thank you, sir.
I thank Professor Khan, and also my family of
Thank you, sir.
HNLU, which by which I could really be participating in this occasion. And of course, a special thanks to my friend, your VC, all put together. I would say that have a wonderful time, have a good evening, and be safe. And if you're not vaccinated, please go and take your vaccine at the first possible chance. Thank you.
Thank you. Thank you, sir. Thank you so much.
Thank you very much, sir, for your concluding remarks and inspirational talk at the end of this today presentation. So we came to the end of the session of this particular Sui Generis 2 today's session by Dr. Atif Khan. So with the permission of the Honorable Vice Chancellor and our guest faculty, Dr. Anindya Sarkar, so I would like to conclude the session. I think VC sir is not there, so we can conclude the session. Thank you all.
Thank you so much. Thank you so much.